Hi, my name is Willem Oostdyck and I'm a registered migration agent here at Sirus Migration. I'm here today with my colleague, Yossi Witkowski, and we thought that we're going to discuss a couple of issues that might be important for our clients to know. And the main issue today will be how to lodge a review application at the Administrative Appeals Tribunal and some of the pitfalls in relation to that process.
Well, thanks for the discussion that we had previously. I think what's important that I think maybe the audience would like to know, and me personally also, is I know that there's certain procedures involved. Okay, but how does one get to the AAT? I mean, how do you launch an application?
Yeah, okay, so that's a very good question, Yossi. So there's probably several ways that one can arrive at the Administrative Appeals Tribunal, and we'll call it the AAT abbreviation. When a visa is refused, there's an opportunity for the matter to be reviewed at the Administrative Appeals Tribunal. If a visa is cancelled, the same thing can happen. Okay, so we can lodge an application to the tribunal. But what we need to understand is that there's a time frame, deficit time frame between refusals, cancellations, and it's important to understand that we need to watch it within a statutory time frame.
So is that time frame important? I mean, what if you go over the time frame? Is there any form of condemnation? Anything if you go over the time frame? Is it an important time frame?
Yep. So for example, with a visa refusal, let's say, for example, a student had a visa refused because he failed to provide a confirmation of enrollment at the time of application. Then he will be notified by immigration that the visa has been refused. Perhaps you might get a natural justice letter before that to find some comments. But if the then visa is refused, he has 21 days to lodge a review application at the tribunal.
So it's quite important to keep to those days.
It's a statutory time frame, and if it's lodged past that time frame, then the decision will be out of jurisdiction, and there's no review for that decision.
So, well, you mentioned visa refusals and you mentioned visa cancellations. Is there a difference? So basically, my understanding, visa refusal, just let me know if I'm correct, visa refusal would be when you're applying for the visa.
That's right, you're not hold the visa yet.
You don't hold the visa yet.
You have an application in the system, and then it will be decided, will be assessed, determined whether it is grounded or to be refused.
Visa cancellation is when you already hold the visa, but they cancel your visa.
That's correct. So you hold the visa, and for instance, let's just use the student example again. If a student, for example, breaches his visa condition, condition 202, for example, does not maintain enrollment in his course, or perhaps maybe works additional hours than actually supposed to, 20 hours a week. Right? So that will be a breach of this condition. That will lead to a cancellation of the visa. Or, for example, if a person provides incorrect information, false certificates, false English certificates, false documents in relation to skills assessment, all those will lead to visa cancellation under PRC 420, the public interest.
So, Willem, I now received the visa cancellation or a visa refusal. I'm anxious. What's the next steps?
Yeah, that's important. So the next step is, first of all, as we mentioned before, we need to consider the time frame. So visa refusal is 21 days, visa is cancelled, it's 7 days, it's not sure, but that's 7 days, so it's a bit of time to play around. The application can be made online at the AAT, that's the website. The form will come down, uploads, you complete the details, and it's very important to attach the decision record and a notification letter that you received in relation to the refusal with the online application. You then will be prompted to pay the fee, and then the application is lodged. What happens after that? Probably within about 7 days, you will receive an acknowledgement letter saying that the application has been received. But that's not being assessed to be a valid application until they determine that the fee has been paid, that's in the statutory time frame lodged, and that the notification letter and the decision record is attached to the online application. information.
So, Willem, you've now lodged a valid application. What happens next?
So the next step will be probably a waiting game. The case load before the tribunal currently is anywhere from 15 to 20 months. Some cases can be longer, some cases can be shorter. Some cases are prioritised. For example, Section 501 cancellations often are prioritised. They also reviewed at different part of the tribunal. It's a general division. We're talking today about the migration division. So what happens is that we have this time frame, and we have this time to provide further information to the tribunal, to inform the tribunal about why we believe that the decision is wrong, and that provides a reasonable time frame to provide further information in respect to the decision that has been made. Some decisions will provide opportunity to provide further information. We must understand that the tribunal steps inside the shoes of the decision maker and completely reassesses the whole application. Like it's a fresh new application.
So, like it's a brand new application.
Like a brand new application. And so that's important to understand because it provides an opportunity to really redo the application. For example, with a nomination in subclass 186 visa or 187, nominations refused. There's a whole list of documents that is required for a nomination to be granted or approved. And so that's an opportunity to really provide further information. The tribunal will actually ask for information to be provided at a certain time.
So it's almost like a second bite of the cherry, basically.
Absolutely, yeah.
Because they consider it
and that's
from the beginning to the end.
Exactly, that's very good. So that's why it's so important for clients to understand that, that this is an opportunity to, second bite of the cherry. It's not a lost case. And matters can turn on a very small, minor issue, and sometimes it's a limited situation.
It seems quite technical. That's where probably an experienced migration agent like yourself comes in, because it seems quite technical at that stage. Because now you have to represent the client properly, and there's legal technicalities. I would imagine involved.
So some of the review applications are pretty straightforward. Some are quite complex. Let me give you an example of a complex situation. So, for example, let's say hypothetically a visa has been cancelled. Cancelled on the criteria previously referenced. Perhaps both documents have been provided. Immigration has got to notice, and sometimes immigration conducts investigative methods to obtain information. They provide that information to the tribunal, and they call it Certificate 375. That information is then before the tribunal, and that information might be a reason why the tribunal might make a decision to affirm the decision on the basis of the information. However, the tribunal has also an obligation under Section 359A of the Act to inform the applicant that they have received information from immigration about this finding. So this is where it becomes really complex, and probably this is a time where an applicant client needs to maybe consult with a migration agent in order to be represented at the tribunal.
Yeah, I think for me, I would encourage anybody, if you got a second bite at the cherry, and this is your chance, your one chance to get your visa granted, consult a professional.
It's not cheap too, they pay fees, they pay professional fees, and so you want to do it right.
So, Willem, I'm a student. I had my visa refused. I come to you because you're the expert. What are you going to do for me?
Well, there's a bit of work to be done. The first thing we do is make sure that everything has been lodged. We've got the paperwork in order. We've got the notification from the tribunal that it's a valid application. So a little bit. The next step is to make sure that we have all the documents on record. Now, we might not always have all the documents. It's quite common for students, to say, "Well, I didn't have it or can't find it." I got this, but I haven't got that. So it's important that you have all the documents. And the first thing that we would do as a representative is to approach the tribunal. And we can do it two ways. We can send a request on the freedom of information, or under section 362A, provide us with written materials. That will give us the whole file, the whole student file, exactly what the tribunal would have, in their decision. Once we have that, we can then assess the file to look at, whether there's any errors being made, in decision making. We can look at the legislation, whether, we look at, who's the right legislation. And so that gives us a good understanding of, why the decision has been made. We then proceed with drafting a submission to the tribunal, and making sure that we address the reasons for the refusal in respect to the legislation, the regulations, but also that we look at policy. Immigration policy has some directions how or why they make certain decisions, and it's especially important because that is quite subjective. You can actually draft an argument to say, well, we don't agree with that, because ultimately the tribunal must apply the law the same as immigration requires, but are not bound by policy. So therefore there's an opportunity to, provide a good argument and say, we don't agree with that, and give a reason why.
Okay, so it sounds pretty intense. You have to get all the documentation, you have to look at legislation, you have to look at policy, you're obviously consulting with the client and reading all the documentation, and then you're writing up a proper submission, a proper argument, looking at all those factors.
And during the, probably prior to the hearing, the hearing will be scheduled for a review hearing. The tribunal will send out probably an invitation to provide further information. So that's probably the timeline we probably will submit your submissions. But at any time prior to that, we will be in a position to provide that information. But certainly the tribunal will be making you aware of now as the time to provide us with up-to-date information, and you will be ready by that time.
So Willem, so you've made your submissions, you've done all the legal work that you guys do, worked your magic, you received a date for the hearing, there's a hearing coming up. Is it like court? I mean, I know how court works. I mean, what happens at the hearing?
Okay, yes, often the applicant or our clients have a perception that it's like court, but it's a bit more relaxed. But it's still formal. So we arrive at the hearing. The client and witnesses and interpreters are sworn in. It is to be understood that the representative of the migration agent, if there is such a person involved, that person is not sworn in. That person is there purely to observe the tribunal and make any further submission orally or maybe perhaps in writing afterwards to support the client. We don't take the case. So all the questions that are raised by the tribunal will be directed at the client and the applicants.
Okay, so at the applicant, not at the immigration officer or immigration lawyer, immigration agent or immigration lawyer.
That's right, so it's all directed at the client. At any time, the client can ask the tribunal to stop to consult with his representative to make sure he's on track. There might be a situation where he's not certain about a certain question. We recommend that clients never try to answer a question, with vague answers. You don't know an answer. You say, I don't know the answer. I'd like to consult with my representative.
Yeah, because it can be quite daunting. If I'm faced with the hearing, I had my visa refused, I'm going with my immigration lawyer or migration agent to the hearing. It's daunting because everything, a large part of my life depends on that visa being granted. And so I want to confer with my migration agent or immigration lawyer.
That's what it's there for. And let me give you an example where it becomes real daunting. Let's say, for example, you have a partner visa, spouse visa refused, and you have the sponsor there, and you have the applicant there. Well, what the tribunal normally does is they ask the sponsor to sit outside the hearing room. They ask questions at the applicant for 45 minutes, and then they bring the sponsor in. They ask them the same questions, and then they do ask them questions to see if there's any inconsistencies with the information. And if there's any inconsistencies, the Tribunal will let you know.
So, Willem, I've been at the hearing now, the hearing's finished. What happens next?
Okay, yeah, so we'll probably spend about 2 or 3 hours at the hearing, and the member concludes the hearing. Sometimes there might be a situation where the Tribunal, the member, wants further information to be provided. Sometimes they might disclose, that, look, we have adverse information, or, that might form part of the reason why we're going to affirm the decision. If you are notified in that sort of situation, it's then important probably for a representative to raise their hand and say, look, we'd like to provide further information, if possible, at a time mutually acceptable to the member and the client. Because it might be, a situation where we maybe have further information that could be relevant to that adverse finding. Yeah. Okay. But sometimes, a member makes a decision on the day. They might have enough information now to make a decision. It's a clear-cut case, and there's no reason to delay anything further. We remit the matter back to immigration, or we set aside the decision, and if the matter is remitted back to immigration, then immigration then processes it, looks at the character issues, the health issues, and then the visa will be done.
So, Willem, I received a visa refusal or a visa cancellation. Okay. And besides myself, why use a migration agent or immigration lawyer? I can do this myself, can't I? Why should I go to a migration agent?
Sure. Of course you can do it yourself. You can represent yourself in court, you can represent yourself with the Tribunal. You can build your own house. Will you build your own house?
No,
I think you will find many complexities.
I'll use a builder. I'll use a builder.
And therefore, we recommend that you use a registered migration agent. Hi guys. Well, that concludes our video series on the Administrative Appeals Tribunal, visa refusals and visa cancellations. Elsie has left the building. Please, if you have any further questions in relation to what we spoke about today, if you have a situation like a visa refusal or cancellation, please email us. We're here to help you, and thank you for watching.